Today on Go Ahead Ask, many podcasts focus on buying and selling real estate. But what about the closing and the settlement processes involved when you're buying and selling real estate? Let's unravel that mystery today on Go Ahead Ask.
Building wealth in real estate? Let the Exeter Group take the mystery out of how it's done on Go Ahead Ask.
Welcome to the Go Ahead Ask podcast by the Exeter Group, where we unravel the mystery of investment real estate. Our objective is to provide investors with better quality information so that they can make better informed investment decisions. My name is Bill Exeter. I'm Chief Executive Officer of Exeter 1031 Exchange Services and your host today. The Exeter Group of companies includes Exeter 1031 Exchange Services. Exeter 1031 administers all types of 1031 exchanges. It covers all 50 states. We also are one of the few qualified intermediaries that can handle foreign property 1031 exchange transactions. The Exeter Group also includes Exeter Trust Company. Exeter Trust Company serves as custodian for self-directed IRAs, as trustee for title holding trust or land trust, and general custody services. Here on Go Ahead Ask, we encourage questions and or topics. So you can send your questions and topics to ask@exeterco.com or give us a call at area code 619-239-3091. And if you love Go Ahead Ask, please like it, subscribe to it, share it, and comment on it. We will respond to all comments that we receive. Today's podcast is entitled Unraveling the Mystery of the Closing and Settlement Process when Buying and Selling Real Estate. You've signed a contract to buy or sell real estate, but are you prepared for the closing and the settlement process? Have you given any thought to who will handle the closing? Should you use an escrow company, a title insurance company, a closing attorney? What about title insurance? What is that exactly? How does the closing process work? And most importantly, how can you prepare and plan for it? We're going to unravel that mystery today on Go Ahead Ask. And we're really excited today to have George Bosh, who's the owner of Oregon Escrow Services, with us to help us unravel that mystery. And George has a phenomenal background, which includes title examiner, escrow officer, residential sales transactions, commercial sales transactions, manufactured home transfers, 1031 exchanges, which of course is near and dear to our heart, business sales, collection escrows, first-time home buyer classes. He was president of the Oregon Escrow Council from 2017 to 2020. So a phenomenal background in escrow and title and closing and settlement services in general. So George, welcome to the Go Ahead Ask podcast.
Thank you, Bill. I appreciate you having me on. It's exciting to be able to educate people and give them more information so that they can make an informed decision.
And of course, the first question is always, how did you get into escrow?
Well, I was looking for a different position. I had a friend that his wife worked for a title company, and the work that I was doing was very detail oriented, and he thought that I would be a good fit. And so applied, and it's been 26 years now since I started out, and I never thought that that initial interview would create a career for me, but it's been up and down and sideways and crazy, as we all know the real estate market is. So it's been an exciting process to learn.
It's always fun to find out how you get into it. And the other question that's related to that, of course, is he still a friend?
Oh, yeah, absolutely. He never returns my calls, but that's okay.
And then give us maybe some interesting facts about you that the listeners might want to know, anything you'd want them to know.
Okay. Well, I was born in Cuba, and so I'm bilingual. And have always had a passion for helping people understand and learn things. And this specifically real estate and the closing process is, so difficult to go through that entire process without having, your brain explode for all the information that comes to you, especially that last hour of the closing process. You get so many things between the beginning of, signing with a real estate agent and starting that, and then trying to understand all the documents that are being thrown at you by, the title company, the lender, the appraiser, and everything in between. sometimes it just feels overwhelming. So it's nice to, have a clean look at things to get a better understanding.
So true. Absolutely. Well, let's dive into the unraveling the mystery of closing and settlement process when buying and selling real estate, and kind of for the beginners who are maybe just now doing their first purchase, or maybe they're just getting ready to sell their first piece of real estate. What is the closing process? How would you describe that to a brand new investor?
Well, as you mentioned at the very beginning of the podcast, you have a sales agreement that is provided to you, and you have reviewed it and signed it. There's going to be some due diligence processes that are in there. One of those is to get a title report. The seller indicates in the sales agreement that they're going to provide free and clear title to you. And so once that sales agreement is deposited in a title and escrow company, then the initial process of getting a title report out, which just shows the condition of title, what liens are against the property. And lien doesn't necessarily have to be a bad thing. It can be just the mortgage. It could be the taxes, of course, but it could be also something negative. A credit report, sorry, not a credit report, but a credit lien with a credit card company, for example, that might have gone to judgment because the seller didn't pay it, or could be medical bills that have gone to judgments, or child support or spousal support from a prior relationship. A lot of different things can affect title. And so having that title report and reviewing it once you receive it is instrumental to understanding the condition of title. And then on the other side, the escrow side is clearing that title, going through and requesting a payoff, for example, from the seller, contacting, the child support division, or let's say there's an estate situation, there might be financial fees that were provided to that owner because they were elderly. That is a lien against the property. So those things are the processes of clearing the title. And then the last part of it is preparing the legal documents to transfer the title to the buyer from the seller. And of course, if the buyer is doing a loan, there's going to be loan documents that the lender will be providing also. So just a short overview of that closing process.
Herb, in fact, as you were talking, it just kind of dawned on me. My wife and I just closed on the sale of property last week, and we had owned it for just shy of 30 years. And 28 years ago, we had a second loan that was actually made by a friend of ours. He lent us money out of his self-directed IRA for the property, secured it by the property. That was paid off a couple of years after that. Last week or 2 weeks before the closing, we found out that the lien had never been reconveyed. It was still on the property.
Sure.
So now the trust company that handled the 1030 or handled the self-directed IRA at that point had gone through 4 different acquisitions. And the current trust company said, we have no evidence of that in our files, so we won't sign off on a reconveyance. And of course, the title company gives us the preliminary title report, and there's the second lien position right there.
Right.
So from that, how often do you see something like that happen? And then what do you typically see as the solution?
It does happen very often, and it could be, as you mentioned, any varied things that are affecting title. And so it's just a process of trying to, track down the actual lien holder or beneficiary so that that person or that company can go ahead and do the release. Oftentimes, as you've just mentioned, those records are unclear or muddled, and so you may have to request that the client contact their original bank from, in this case, 28 years ago, and get a copy of a canceled check or some other proof of payment, a letter. So even though people say you should keep everything for 7 years, if you own a house, you might want to keep it for 20 or 25 years just in case, because something can always pop up. You can always go back to other title companies if you had done, for example, a refinance during that 28-year period as another option, and perhaps one of those title companies might have some record of their due diligence that they did to clear that item and removed it from the title report before it actually showed up. But that doesn't always happen. So it's always good to have, extra records if you can.
As you say, surprises happen. You just have to be prepared to kind of duck and weave and deal with it as the closing gets closer.
Right.
And so we're going through this whole process. How long does this process typically take?
Well, on a cash sale, normally it can take 2 to 3 weeks. Sometimes a little bit sooner if all gears are hitting in order. But if it's a refinance or a loan purchase, then you're looking at anywhere from 4 to 8 weeks. You have the appraisal, of course, that has to be handled. You've got the title report to review, of course, prior to that. Any other contingencies, some repairs, for example, that may need to be addressed by the seller. And then, you have to go through your final loan underwriting. And then at that point, the lender sends the documents to the title company or the escrow company. And then we do an initial balance to make sure that our figures are matching theirs. They may miss a fee, we may miss a fee. And so we want to be sure that we have everything ready before we contact the buyer and the seller to, schedule the signing. And then, of course, some people may need to have some funds transferred from an IRA or a 401k or something like that. And so all those things can delay things. And those documents, of course, have to go back to the lender. Lender does their final review and then gives clearance to the title and escrow company or the escrow company to go ahead and record. And then the home is yours.
And there's time for the celebration at that point.
Yes, exactly.
Although, talk about crazy times. We've seen more and more that are closing fast just because they're all cash transactions right now.
Right.
It's a crazy market.
Yes. So the first-time home buyer or that's going to be doing a loan, fully expect at least 5 or 6 weeks. I think that's a realistic expectation. And there's some delays that happen, like I mentioned, a repair, for example, that might pop up in the appraisal. And there happens to not be a contractor available for a week or so, and then that has to be re-inspected. So a lot of things can affect that closing time.
And we've kind of been talking about the closing process. Let's kind of zero in on the role of escrow and maybe give them an idea of what is the role of escrow, what are the responsibilities. I think a lot of people just think, oh, that's the closing process, and that's kind of the more 30,000 foot level, but really drill in. What do they do?
So the role of an escrow officer is, first off, to be an impartial third party. We can't determine the intent of the contract if there's something unclear. We have to ask. Just had a recent transaction where there was an issue in regards to the rent prorates, and an agreement to occupy that occurred prior to closing. And that agreement occupy says that, I'm going to occupy the property before we actually closed. And there was a discrepancy in the language for that agreement to occupy. And so in trying to determine what their intent was, there were a lot of phone calls back and forth between the two realtors, and then the realtors had to reach out to their clients to make sure that both sides understood what was going to happen. And so that impartiality is really important. And then, of course, from that point, it's a process of reviewing the title report, going through each item or exception that shows, and then addressing it. As I had mentioned a little bit earlier, if there's a loan against the property, the seller, of course, has to be contacted. We need to get their private information so that we can order a payoff. If there's any other type of liens, same situation. Some kind of an authorization form has to be drafted, and then that information has to be secured and provided in the closing statement. And then the preparation of the legal documents, the deed transferring between the seller and the buyer. If it happens to be a seller carryback, then in an escrow, we're authorized to prepare a promissory note and the trust deed, which of course the beneficiary has to approve. There may be a collection escrow set up for the monthly payments and the servicing of the loan. If it's a seller carryback, there's usually a collection escrow company that is assigned to do that work after the close. And then those monthly payments are processed by that company. Then, of course, buyer, of course, brings in the money, and then we're able to get everything recorded. Once we're recorded, then we're able to disperse to the appropriate parties, pay off the realtors, pay off an appraisal, for example, pay the insurance company for the new buyer, of course, provide the proceeds to the seller, and it's a happy day and everybody gets paid.
It's always a happy day when the closing occurs. It's like, phew.
It's over and done with, yes.
And you mentioned like a preparation of a promissory note and mortgage or deed of trust. If there's a seller carryback note and then a collection escrow, does Oregon Escrow Services do that type of work?
I do not do the collection escrow process. I have companies that I have affiliated with for that, just as I've affiliated with your company, Exeter 1031 Exchange. But if it's the initial process, like I said, of drafting those documents that are going to be used by the collection escrow company, I do prepare those documents, yes.
And I think the more sophisticated investors who've done quite a bit of transactions probably know this question answer, but especially for those that are relatively new, how would you describe the differences between like an independent escrow company, an escrow department of a title insurance company, a closing attorney, and how would they, choose which one they should use? What are kind of the pros and cons?
Pardon me. So an independent escrow company is just that. They're working on their own on behalf of the client. The real estate agent is going to provide them the sales agreement, and then if there's no identification in the sales agreement as to which title company is going to be used to prepare the report and issue it, then the escrow officer can go ahead and make that selection, and then of course go through that whole process of clearing title. If it's the order is placed with the title company and they have an in-house escrow employee, which most of them do, then the process is still exactly the same. The sales agreement is provided to the title company. They open up the transaction and then assign an escrow officer. And so obviously in-house can sometimes be more efficient because everyone's all in the same place. Unfortunately, some, or actually most title companies do not like to have their employees leave their office unless it's, extenuating circumstances. Someone's broken a leg, for example, or they're in a hospital. So an independent escrow company has the ability to be mobile and provide those kinds of services. Some states are escrow states and other states are attorney states. And so depending on where you live, you may have to go to an attorney to do a transaction, which is perfectly fine. Of course, they're very qualified, versus a title and escrow company or an independent escrow company.
With all those moving parts, who typically pays for what?
Okay. Well, in Oregon specifically, the sales agreement states very clearly that the seller is to provide free and clear title to the buyer. And so that title insurance policy that the seller is providing is called an owner's policy. And so that becomes the seller's responsibility. Then the escrow fee is split 50-50 between the buyer and the seller. And the other fees are going to be apportioned depending on what they are. So, for example, a reconveyance fee. A reconveyance is the process of removing a loan, a trust deed, or mortgage from that transaction. So because that loan was initiated by the seller, then it stands to reason that that fee should be paid by the seller. Recording fee, it's to the benefit of the buyer for that title to be recorded to put them into title. So that fee is normally paid by the buyer. There can be negotiations on those fees also. So as part of the real estate transaction with the real estate agent, oftentimes there'll be some additional instruction to escrow as to what fee is going to be paid by who. Some people will say, well, we want to split all fees 50-50. And so everything would be split 50-50 because that's what the actual instruction is, and escrow does have to follow written instructions. So it varies depending, I think it'd be a smart thing to have everything split 50-50 because then your loan fees would be paid 50-50 too. But that has to be specified obviously very clearly so that, the escrow officer knows that that's what's going to happen. There could be also other considerations. For example, you may see on a sales agreement, seller has agreed to contribute up to $3,000 towards buyer's closing costs. And so that becomes a charge to the seller and a credit to the buyer. And it doesn't matter what the fees are because, to a certain extent, specifically to the loan, because that $3,000 is going to cover some of the title and escrow fees and some of the lender fees. So again, it's a negotiation. Specifically between the real estate agents, if there are some, and the clients. And escrow just basically follows that paper trail to make sure that there aren't any issues with that process of preparing the closing statement.
And for those listeners who are, contemplating a 1031 exchange, you probably should get a copy, an estimated closing statement a couple days before closing, so you can go through all of those different items. Some of them are permissible selling expenses, which qualify for payment through 1031 exchanges and do not create a small taxable event. Others that are lender related or operational or expense related are probably not permissible selling expenses and are probably going to trigger a slight taxable event if they're paid through escrow. So just kind of a heads up there with whoever's doing an exchange.
And of course, the exchange company.
Oops, sorry.
The exchange company also wants to see a copy of the title report to make sure that there aren't any issues there that might affect something.
True, absolutely. And that's key, is to review all those a couple days prior. So just in case there is an issue that comes up with the 1031 exchange, that can be resolved.
Correct.
And with that, we're going to take a quick break for a message from our sponsor. This episode is sponsored by our sister company, Exeter Trust Company. Did you know that all individual retirement accounts are self-directed IRAs? It's because you choose where to put them. You choose whether to put your self-directed IRA at a bank or at a securities or brokerage firm or a life insurance company. So that makes it self-directed. But did you also know that all IRA custodians are not created equal? Most IRA custodians, like the banks, the securities firms, and the life insurance companies, limit you to publicly traded investments such as stocks and bonds and mutual funds. But some IRA custodians, like Exeter Trust Company, allow investors to invest their IRA funds in other alternative assets such as real estate. Investors can acquire real estate, mortgages, deeds of trust, or tax lien certificates inside the IRA as an investment inside the IRA. To learn more, call Exeter Trust Company at area code 307-222-8750 or visit them on the internet at exetertrustcompany.net. And we're back with George Bosh, who's the owner of Oregon Escrow Services. So let's go back and expand further on unraveling the mystery of the closing and settlement process when buying and selling real estate. And I think one of the things we get questions about the most is title insurance. It's amazing to me. Even some sophisticated investors really don't understand what title insurance is. They just think, oh, that's the way I get title to the property. So maybe expand on that. What is it? Who does it protect?
Sure. There's a number of different title policies out there. The most common ones would be an owner's policy, of course, and a lender's policy. There's also a leasehold policy. There's a purchaser's policy if the transaction happens to be a seller carryback with a contract instead of a note and trust deed. So I'll delve into the two most common ones again: the owner's policy and the lender's policy. The lender's policy has a couple of different types to it also, so it can get a little muddled, but it's not too bad. The owner's policy basically protects that buyer from any issues that are identified in the title report that could affect them. And the most important thing to understand with title insurance is that's being paid one time, and it protects you for the life of your ownership of the property. So like you mentioned, you've owned that property for 28 years, and so you got a title policy at that time. And so should anything have come up after that title policy was issued, it would not protect you for anything from that point forward, because this is after the fact. But anything that occurred prior, prior owner, for example, let's say they died without a will, and then all of a sudden you have an heir from Alaska. The heirs are always from Alaska, by the way. Just kidding. An heir from Alaska knocks on your door and says, "Grandma said that I was supposed to get this property, and here's my will that says that." So that's a cloud on the title. That's an issue with your title because it's something that occurred in the past. It could be a possible fraudulent transfer. There was a case a number of years ago where a husband was having an affair, and his girlfriend signed the deed with him on one of the houses that he owned with his wife. So that was a fraudulent transfer of title, and that occurred prior to to that situation. So, title insurance was able to address that. And so that becomes a claim against that title policy. And there's so many different issues that can come up that could create a possible, claim against the title policy. Could be an easement that was not, drafted correctly, and now you have a boundary issue. There could be a number of different things that can affect it. So that owner's policy protects that buyer from anything that occurred prior to that point that could cloud that title. A lender, of course, they're providing funds to the transaction, so the lender wants to be protected. And so there's a lender's standard policy and a lender's extended policy. The lender's standard policy, again, is protecting the lender from any issues from the buyer side and also from the prior seller that could affect their first lien position in that property. The extended policy adds additional assurances to the transaction. For example, an 8.1, which is an address endorsement, environmental endorsement. There's the 116, which is an address endorsement. So when you normally do a loan, you're getting an extended lender's policy because the lender wants to have those additional coverages to make sure that they've insured the right property. What a concept.
Yeah, that does kind of help when they insure the right property.
Yes.
In fact, you mentioned easements, and that triggered a thought. We had a client just recently who bought a single family, and his intent was to buy the property and they just do some improvements to increase the value. So it's kind of a value play. Mm-hmm. The property really was lacking a full driveway, didn't have a garage, et cetera. And his plan was to expand the driveway, make a circular driveway, add a garage, and put a little work shed in the back, et cetera, and have that all constructed. Mm-hmm. Went through the closing process. Nothing showed up on the preliminary title report. And then after he closed, he went to pull permits and found out there were easements across the back corner of the property for utilities. So he wasn't able to build the garage or the shed in the back, and he couldn't extend the driveway as far as he wanted to. So he argued that the value of the property was limited. It wasn't increased like he had planned. So the title company had to pay the difference on what his loss was.
Right. And obviously those easements were filed or recorded, so they should have shown up, and we're all human. We make mistakes. And, in this crazy, fast-paced world that we live in, it's not unheard of to have an easement or a lien or something, not show up. I had a transaction about 6 or 7 months ago, and there was a judgment against the seller for, I think it was $2,200, $2,300, something like that. And the title company missed it. And so I get a phone call about a month and a half, 2 months later from this creditor wanting to know where his money is. And, that was an expense that I had to incur because the title company did not show that item on there. And when I asked him, oh, well, it was such a small amount. Well, it doesn't matter. It's still a judgment. And it still had to be addressed. And the title company made good on the process, but still it makes your heart skip a couple of beats when you get a phone call saying, "Hey, I'm owed a little bit or a lot." And certainly a little bit is much easier to swallow than $100,000 or something like that.
So true. And in today's world, everyone's worried about identity theft and things like that too. And going through this closing process, title, escrow, closing attorneys ask for all sorts of personal information. So can you kind of comment on why are they asked for? What are they asked for? What does it do? And how do they get protected?
Sure. Well, one of the things that oftentimes occurs, especially with people that have very common names, John Q. Public, right? John Q. Smith, is that there's going to be a couple of hundred John Q. Smiths out there, right? And so one of the documents that a title company may request that a buyer do is called a statement of ID. And so that provides the title company additional information such as social security number, of course, date of birth, prior addresses, prior marriages, different things like that, where they can then extrapolate that information and go to the courthouse and confirm whether this judgment that is appearing to be for this person is truly theirs, or if they can sign off on it because it's a similar name, but the social security numbers are of course different, and so that information of course is protected, and we usually would mail out a document like that or hand deliver it, or send it electronically via a secure file server so that it can be filled out and returned. On the seller side, of course, we need to have a social security number and of course signature in order to get a payoff. There's also IRS forms and state tax forms that have to be filled out as part of that closing process on the seller side. On the buyer side, of course, there's going to be a W-9 with the loan package. So all of this information going back and forth, it needs to be sent in a secure manner. And so we're always very cautious about that. And I'm going to make a declaratory statement. Wire fraud is real. So if you receive wiring information from your title company, it will not change. And so you should, when you receive that wiring information, contact your title and escrow officer and confirm that information verbally before you wire any money, whether it's earnest money or proceeds for a sale, proceeds for a purchase. It's very important that we stop wire fraud every way we can.
Absolutely. In fact, we do verbal confirmations of wire instructions for every single wire we send out. I don't care if it's $1 or $1 million or 10 million. And we probably catch 1 to 2 fraudulent attempts every month. It's amazing how fraudsters will intercept emails, reconfigure, change the wire transfer instructions, and then send them to either the taxpayer or the escrow or the exchange company. And if you don't call to verify those wire transfer instructions, you're going to be a very unhappy camper. But chances are there may not be anything you can do once you discover the fraud.
Yes. Matter of fact, I was at a client's house a few years ago, and I was visiting with him. He was the buyer. The real estate agent was there, and we made a phone call to his brother, who was going to be wire transferring the funds for his purchase. And the very next day, I get a phone call purported to be from that brother, requesting that I send them, the wiring instructions. And I, spoke to the gentleman. I was actually driving up to Washington State to attend a conference there. And I spoke to the gentleman and I said, he wasn't a gentleman. Said, this is not Mr. So-and-so, because I spoke to Mr. So-and-so yesterday and he has the information that is needed for that. So I'm not going to be providing you any wiring instructions. And we were able to track it down to the realtor's email address being hacked. And so she, received that information, of course, that I had emailed to her and CC'd to the buyer's brother, and they were trying to get the buyer's brother to wire transfer to a different location. So we were able to get that stopped.
And we've spoken to people who actually have gone through with it, sent the wire, and then they're out. And in fact, there was an escrow company here in Southern California that, they had the same thing happen to them, and they actually sent out a $900,000 wire. And because they couldn't recover and replace that and didn't have proper insurance, the state of California closed them down. And it wasn't their fault that they got that fraudulent attempt, but they executed without verifying wire transfer instructions, and they're now out of business. So that's critical that you verify.
Absolutely.
So at the beginning of the podcast, I was kind of alluding to, how do you get ready for the closing process? How do you prepare? Because it's all about planning and getting ready for this process. So what can the buyer and seller expect to happen at the closing appointment? And what can they do to kind of help prepare for that so it's very efficient and smooth?
Sure. Well, certainly it should be an obvious thing. Ask any questions you have whatsoever throughout the process. We're here to serve and to educate and to make things as easy as possible. The normal process is, I mentioned, pretty lengthy sometimes, depending on the transaction, and it's good to have some checklists so you can get a checklist, for example, from your realtor. I have a short one that I provide to people so they understand what steps they need to take. For example, getting insurance ahead of time, uh, making sure that they have their banking information, for example, for the seller, so that we're not having to, to try to do that during the closing table. So whether it's, just their checkbook, or if they want to have their funds wire transferred, you want to have them bring that to the closing table. The buyer, of course, needs to do the same thing, provide funds. And so, we would do whatever we can to make sure they have that information ahead of time, so that they can, be better prepared. And then normally I would say allow at least an hour to review all the documents. It's a lot of information to go through. And, we do a cursory explanation of each document, because of course we've certainly been working with them for many, many years, right? And we understand it. But again, throughout that process, whether it's prior to the closing table or during that closing process, signing the documents, any questions you have, better to ask them and be sure that you understand, than to walk away and feel muddled and confused.
And what does they say? Ignorance is no excuse.
Is that what they say?
If you don't know, ask. Otherwise,
Yeah.
once you sign, you might regret it.
Right. Or the other one, there are no stupid questions unless you've asked them, right?
That's
I think that's how that goes. And it's better to be sure, and like, as I had mentioned, a little while ago, being bilingual Spanish, to me, it's important that the client understands. And so I take my time making sure that they understand, whether I'm speaking in Spanish or I'm speaking in English. It's hard enough in English to try to explain things, let alone to try to explain it in a foreign language where, property rights are not as easily processed as they are in the United States and in some foreign countries. So, it's kind of really is a foreign language to a lot of people. And you only buy or sell a house, a couple of times, in your lifetime. You may refinance a little bit more often, but of course that process is the same. So you're not exposed to the terminology and such as much. And so, I kind of don't want to sound like a used car salesman and just rush through the paperwork and, and have them just, sign here, sign here, sign here. And then they walk away not really understanding what they signed,
And certainly some of the terms, and even when you get into some of the more sophisticated transactions like 1031 exchanges or what have you, doesn't always translate well into other languages like Spanish or what have you. It's difficult to explain some of those concepts.
Quite true. And the strategies and the guidance that Exeter 1031 Exchange provides to their clients, I think is invaluable. And I appreciate my partnership with you.
And one of the questions we get usually after the transaction is, how do I get my deed? And of course, clients often get confused too between, grant deeds and warranty deeds and quitclaim deeds and deeds of trust and mortgages, et cetera. So maybe kind of run through those and, how can the client get a copy?
Right. Well, the original, of course, is being signed by the seller, and then that document gets recorded with the county. The county will have a permanent record of it. And then that original is normally sent either by the county or by the title company along with the title policy to the client. And so that original should come, in the mail within a matter of weeks of the transaction closing. And then the lender, of course, gets their title policy and their mortgage back too. That information is now public once it goes, into the county record. And so oftentimes you'll start receiving mailers after the fact, because again, that information is now public. And there's companies out there that will try to, get you to sign, or not get you to sign, get you to, pay them to get a certified copy of the deed while you're getting the original in the mail. So you don't need to have a certified copy. And so there's always the opportunity for fraud. And so, people need to be aware of that. Title company is going to be sending you that original deed. You don't need to pay for any extra deed copies unless you want to.
There's always somebody who tries to take advantage of different areas.
Right.
It just drives me crazy.
Yes. Well, it's a market-driven economy, and, they're just being capitalists.
Absolutely.
I don't have a problem with that within reason.
Exactly right. Well, this has been a lot of great information. So if listeners wanted to get in touch with you, how can they best reach out and touch base with you?
Thank you. My website is www.oregonescrowservices.com, and my phone number is 541-530-0001. I'm licensed to do escrows in Oregon only, but I certainly have no issues, helping people understand the process and giving a little bit of education if they might have a one-off question that I might be able to answer.
Perfect. And thank you again for joining us, George. That was a lot of great information. Hopefully it's going to help the beginners and those that are less experienced with the closing process kind of get through all of that. And thank you, everyone else, for listening to Go Ahead Ask podcast today. If you love Go Ahead Ask, please, again, like it, subscribe to it, share it, and comment on it. We will respond to questions and answer questions, whatever that might be. If you have topics or questions you'd like us to cover, go ahead and email them to us at ask@exeterco.com or call us at area code 619-239-3091. Thanks again for listening. We'll see you next time.
Thank you for listening to Go Ahead Ask with the Exeter Group. Join us for our next episode when we further unravel the mysteries of real estate.